Doing? Hank Chambers, University of Richmond. I think I've seen you all before somewhere.
Hey, good morning, Virginia. My name is Thomas Mackey. I'm in the history department at the University of Louisville and with the Brandeis School of Law at U of L.
Good morning. I'm Rita McCannon. I'm a lawyer in Huntsville, Alabama, and I'm so glad to be with you today. And I'm so proud of all of you all for the work that you have done to get here. Please introduce yourselves.
I'm Mary Caroline Heinen.
I'm Isabelle Georges.
I'm Naja Baraka.
I'm Julia Ochsenhirt, and our coach is Samuel Schneider.
Good morning.
Fantastic. Fantastic. So we're going to jump right into question 3, unit 3. I'll read the question and then we'll hear your opening statement. So in 2020, we celebrate the ratification of the 19th Amendment, which recognized the right of women to vote. Despite recent controversy, the Equal Rights Amendment has not yet been declared ratified. What are the similarities and differences between these two amendments? What impact, if any, has the 19th Amendment had on women in achieving equality with men in the United States and around the world? What are the advantages and disadvantages of states passing their own equal rights amendments rather than ratifying a national constitutional amendment? We're ready for your opening statement.
Ratified in 1920, the 19th Amendment was a major success for suffragists and others who had fought for women's rights since the 1800s. However, winning the right to vote did not secure equality outside the polling booth. Almost immediately after the ratification of the 19th Amendment, suffragists turned their sights towards broader social and legal equality between men and women. Alice Paul and other suffragists in the National Women's Party drafted the Equal Rights Amendment, but it wouldn't be sent to their states for ratification until nearly 50 years later in 1972.
While the goal of the 19th Amendment was limited to voting rights, the ERA encompasses broader goals for legal equality, similar to the 14th Amendment. However, some of the protections of the ERA are already included under the court's interpretation of the 14th Amendment. For example, in Reed v. Reed, the court used the Equal Protection Clause to ensure women could be appointed as state administrators. Even so, the ERA would have broader impact, from greater enforcement of wage equality to limits on single-sex institutions. The ERA would also allow the court to examine cases involving gender with strict scrutiny, rather than the intermediate level utilized under the 14th Amendment. The ERA and 19th Amendment have some similarities. Both amendments are phrased as negative rights, preventing government action rather than upholding a right. Neither amendment seeks to address social inequalities faced by women, but through expansions of political and legal equality, this should follow.
Even without the ratification of the ERA in the 20th century, court decisions have continued the movement for women's rights. Landmark legislation and lawsuits regarding the 14th Amendment's Equal Protection Clause have been critical in helping women achieve legal, economic, and social equality. For example, the 1974 case Corning Glassworks v. Brennan struck down a loophole perpetuating the gender pay gap, which was formally outlawed in the Equal Pay Act of 1963, and gave women the legal precedent necessary to fight wage discrimination in the future. JEB v. Alabama secured women their Sixth Amendment right to a jury of their peers by outlawing peremptory strikes based on gender. Furthermore, legislation like Title VII of the Civil Rights Act of 1964, Title IX of the Education Amendments of 1972, and the Family and Medical Leave Act have ensured women had equal rights to education and that they could not be fired or refused a job due to pregnancy. The 19th Amendment was part of a much larger movement that still continues today with measures like the ERA.
One critical part of the movement to pass the 19th Amendment was states granting women the right to vote before a national amendment was passed. Many Western states, like Wyoming, granted suffrage to women decades before the 19th Amendment was passed, and as more states followed, the suffrage movement gained strength. A similar tactic could work with the ERA, as convincing one state at a time to put gender equality into their state constitutions could eventually build to a national amendment as the movement gains ground. Since the national movement slowed and the ratification deadline passed before the necessary 38 states ratified the ERA, women's rights advocates shifted to focus on state ERAs because they are often easier to ratify in state constitutions quickly.
One drawback, however, is that state equal rights amendments could lead to widespread confusion. If the wording of each state's ERA was not identical, conflicts over what constitutes equal rights could ensue. In these cases, only a national ERA with the authority of the Supremacy Clause of the Federal Constitution would allow the national government to step in and make a governing decision. A national ERA would provide more clarity and give Congress the power to protect and expand legislation, such as the Equal Pay Act and Title IX through the Enabling Clause. It would also give the Supreme Court a stronger basis for deciding in favor of equal rights and would require a level of strict scrutiny to be applied to all bills requiring different treatment based on sex. Although state amendments have a role to play in the issue of gender inequality, a national amendment is required to create a long-term effective solution. Thank you.
All right. So is the ERA necessary, given what you all said about the 14th Amendment?
Yeah, and the Equal Protection Clause, it sure sounds like that's the right question.
I would say that yes, the ERA is still necessary. While some protections based on gender inequality have been utilized using the 14th Amendment's Equal Protection Clause, the ERA still provides the broadest level of protection, as it would allow the court to use a strict scrutiny standard rather than the intermediate scrutiny standard established in the case Craig v. Boren.
Additionally, although we do have substantial protections in some areas, such as employment and in education, there are still many arenas in which women are substantially discriminated against. For example, there are a lot of limits on reproductive health care. Currently, 6 states allow pharmacists to deny women emergency contraception, and there are lots of limits on abortion, such as trap laws, that only affect women, and these likely would not be upheld by strict scrutiny.
Additionally, if you look at the 14th Amendment as well as the intent of the creators of the 14th Amendment, it wasn't created with women in mind. Instead, it was created to help newly freed slaves. So included protections for race and national, ethnicity. So it wasn't created with women in mind. And as RBG once said, it's important to create an amendment that protects women just as it protects other people based off their individual merit and not the unalterable trait of birth, such as race or gender.
Is legislation that is explicitly pro-women constitutional under the ERA?
I would say that yes, a lot of this legislation that is for women would be constitutional under the ERA as long as it passes the strict scrutiny standard of fulfilling a compelling government interest.
And many laws like this happen in regards to race, such as affirmative action. It is explicitly pro-minorities, and so that legislation has been allowed to pass and not seen as discriminatory. So there's, as long as it passes this test, it's okay.
And the court has ruled in favor of programs within employment that uphold women. For example, in the case Johnson v. Transportation Agency, the court upheld an affirmative action employer in promoting a woman over a man, using her or taking her gender into account because it didn't constitute an absolute barrier against men or a quota system as struck down by the court in cases of race.
Okay.
Yeah, I'm still troubled by this idea that we have the Equal Rights Amendment, but we can still have preferential laws that benefit only women. So let me then shift a little bit and say, you talk about the amendment mentioned sex, but then you talked about gender. Do you see those as equivalent? How do you understand that?
As of right now, the ERA is worded in the words of sex, and so it isn't clear if it would really extend to more than just your biological sex, but that would be another step that would be further after an ERA.
How would you deal with that if you were a judge?
Yeah.
I think in most cases, judges and the law can consider sex and gender to be the same, though they are different in a personal and societal reason, because even if a person identifies as a different gender than their sex, discriminating against them would still be discrimination on the basis of sex because their biological sex is different from their presented gender.
And that gets me to where I wanted to go, which is bringing about this change. Is that going to be brought about by constitutional amendments or federal statutes, or is this going to be brought about by cultural change over time? If so, then maybe the ERA is superfluous.
The purpose of the ERA is, as a constitutional amendment, would be to make it so that federal laws and state laws can be less discriminatory based on gender or sex. And so although cultural change and societal change also helps this along, the implementation of a national ERA would allow laws to be evaluated clearly.
In addition, let me jump in. I'm sorry, just one, since we only have 1 minute. You're talking about cultural change, and then we've had ERA for a long, long time. Why have we not had more women elected?
I think that's based more in the social culture of the United States rather than something that the ERA can change. If we pass the ERA, we can't force Congress to be 50% women. It's just, that's more of a social aspect that people aren't electing women.
And additionally, I do believe that the symbolic force of the ERA in saying that as a nation, we do believe that men and women are equal and we're cementing it in our Constitution would help perhaps sway public opinion and help to get more women into office. So that's one of the reasons that I'm in favor of the ERA.
But if it's just a symbol, so what? So it's kind of like prohibition. We meant well, but we didn't really mean it.
Well, it's not,
Go ahead, finish.
Go ahead.
It's not simply a symbol, it's just that a national ERA would have such a symbolic force in promoting the social aspect, but it would still have a very legal aspect with the strict scrutiny standard.
Yeah.
Thank y'all very much. Thank y'all very much. Fellow judges, comments?
I always want to be difficult, and I do a good job of that. And this question on its surface doesn't look that difficult, but in fact, you start dealing with this mix of constitutional principles, legal values, as well as cultural assumptions. And this question turns out to be much more difficult and complicated than it might seem on its surface. So in trying to make sense of this, I thought you did a really nice job of both the laying out the major issues, a good sense of the case law that comes forward, and mapping out both where we are and where we might go in time, depending on culture as well as legal change. But it was a very nice job, folks.
You left me with nothing to ask. I thought you did such a nice job, and when one of you stopped, the other one jumped in. You all knew about cultural change. You knew about things changing back with the 14th and 15th Amendments. You knew about the employment law. I wanted to talk to you a little bit more about why I don't make as much as the next guy down the street, but that's okay. We didn't get there. But I appreciate so much all the preparation you did. We are in a very difficult time right now. And I don't know how y'all are doing staying at home all the time like I am, but to get this prepared and do all the work that you did and present the way you did today makes me get emotional like I did yesterday. So I'm going to stop right now.
Yeah, it's good work, hard question. It's difficult in part because what folks were thinking about with the ERA in 1972 is very different than what we think about in terms of sex and gender today, and what we can protect and what we can't. Good stuff in terms of the affirmative action piece, which is similar as well as a lot of folks are now saying, hey, why don't we just do away with affirmative action? So it's a very, very tough kind of question. And I think y'all handle it very, very, very well, particularly under circumstances like these. So thank y'all again. Obviously good to see y'all, and good work.
Yeah, congrats to the teacher.